The world is changing rapidly.
And that's why private dispute resolution has never been more important.
The Chartered Institute of Arbitrators, also known as Ciarb,
is a global membership body of arbitrators, mediators, and adjudicators,
and other private dispute resolution practitioners.
We are the world's largest dispute resolution community,
comprising more than 18,000 members connected through 44 branches across 150 jurisdictions.
While no two private dispute resolution professionals are the same,
we are all committed to access to justice.
When it comes to training,
FCIArb is a global community and a global powerhouse,
investing and reinvesting both in our members and our profession.
Ciarb has set the benchmark with our chartered status,
which represents excellence in practice.
Our calendar of events, webinars, ongoing learning and lectures
are thought-provoking
and provide a chance for our members to connect and learn from each other.
Ciarb is more than a membership organization.
It's my professional home.
It's my professional home.
It's my community and my professional home.
Thank you very much, and just in case you have forgotten, my name is MacIntyre, and I am the CEO of Ciarb. And first, I'd like to welcome everybody who's here today. This year's Alexander Lecture is delivered, of course, by Dr. Mohamed Abdel Wahab on the topic of arbitrating in an age of legal fracture, guarding the realm and system recalibration. Quite an impressive title. I'm looking forward to it, Mohamed. First, a warm welcome to everybody online, and thank you for joining us and participating from virtually all over the world. I'm told we have somewhere in the region of 1,500 people online and registered online. For the first time in many years, Ciarb is hosting the Alexander Lecture outside of our offices. I felt it was time that we look towards a bigger crowd and engaging people a lot more. And the opportunity of doing it here at the LCIA function that we have is an excellent opportunity. We are truly delighted to be in this fantastic venue, to be joined by so many of you from across the global community, including members and representatives from over 44 branches, the future presidents, trustees, and more. Thank you for being here. I would also like to remember colleagues and friends who, although sadly no longer with us, are still present in our hearts and minds. Just a few days ago, we said a fond farewell to Professor Niall Bunny, who was co-founder and former chair and patron of the Ciarb Ireland branch, and a former Ciarb president. Although we feel his loss deeply, we celebrate his life and the lasting contribution he has made to your profession. I would like to extend our congratulations to the organizers of London Arbitration Week for delivering an exciting and ambitious flagship program. I am confident that the London Arbitration Week will become a cornerstone in the global disputes calendar, and we are pleased to present the Alexander Lecture as part of the 2025 program. Before we begin the lecture, let me have a quick roadmap of the evening. First, we will hear from Professor Abdel Wahab. This will be followed by a Q&A session moderated by Ciarb's past president, Anne, with questions from both the room and our virtual audience. After that, we will move into our presidential handover ceremony. And finally, we invite those of you attending in person to join us for an evening reception. With that, I would now like to introduce tonight's speaker. Professor Dr. Mohamed Abdel Wahab is a man that needs very little introduction, but I'm going to take this part anyhow. Not because I shouldn't give him one, but because his list of accolades is long enough to require its own keynote slot. It is quite an amazing career so far. Mohamed is a globally recognized thought leader in international arbitration, having served in over 280 cases around the world. His work has shaped modern arbitration. From his influential roles within Ciarb, the ICC, and ICCA, to his award-winning scholarship, he continues to set standards that many of us simply try to keep up with. This list, and forgive me, Mohamed, I need to go through it, so I'm going to. He is the founding partner and head of international arbitration, construction, energy at CIArb and Partners. Professor of International Arbitration, Private International Law, English Contract Law at Ciarb University. Member of ICA Governing Board, Chair of the ICC Governing Body for Dispute Resolution Services, Dean of the African Arbitration Academy, member of the Curatorium of the Hague Academy of International Law, member of the ITA Academic Council, member of the Court of Arbitration, PCA, and a member of the Court of Arbitration, LACIAC. The list probably does go on, but that's what I've captured so far. And for those are just a few of Professor Abdel Wahab's many, many roles. He is a multiple award-winning who is regularly ranked by the Who's Who Legal Chambers, the Legal 500, the Client Choice Awards, as a world-leading international arbitration thought leader, counsel, and arbitrator. And I count him as a friend as well. He's the author and co-editor of a number of authoritative publications and a highly sought-after, preeminent educator. Please join me in providing a warm welcome to our 2025 Ciarb President, Alexander Lecture Professor Abdel Wahab.
It's a privilege and it's a pleasure to stand before you today. Now, I have limited time to go through what I think is a very important topic, and we've had an excellent keynote yesterday by Professor Bricolakis in the flagship conference in the rule of law and arbitration. My topic today is one that I thought about a lot. Before doing that, I would like to welcome you all, Your Excellencies, Lordships, and Honourable Justices and Judges, members of the Chartered Institute of Arbitrators, the Board of Trustees, distinguished colleagues, friends, and guests who are appearing in person and online. It is a distinct pleasure to be invited to deliver the Alexander Lecture. And just as a point of good order, that invitation which I received was before being elected as President of the CIArb. It is with profound humility and immense pride that I stand before you today in London, a city whose very cobblestones are steeped in history of law, justice, and the endless pursuit of the rule of law, a theme that defines and shapes the discussions during this week of the law, the London Arbitration Week. In September 2025, when I finally settled on the topic and the theme for this lecture, I was acutely aware that I was venturing into treacherous waters, and indeed a perilous task to express views and thoughts on a topic that is multifaceted, highly controversial, and divides the legal profession and players in the field of international law and international arbitration, without risking coming across as polemic or bearing the stigma or the label of being a champion of a challenging winter for international law and arbitration, or a supporter of a reigning spring for either. Now, moving to the structure and substance of my lecture, I will start with one introductory remark. Then I will move to address what I call the legal fracture, then the realms and international arbitration, and then finally concluding observations on system recalibration between exaggerating, moderating, and dissipating perceptions. Now, in terms of my introductory remark, that actually focuses on the first word of the title, arbitrating. And if we talk about arbitrating, then the focus, from my perspective, ought to be on international arbitrators, who are indeed facing novel, unprecedented, and multifaceted challenges. Challenges that are normally not given the attention that ought to be given. Much is said about arbitration as a process, its decision-making, its success and failures, and perhaps the critique of arbitrators, but less attention is given to the condition under which responsible arbitrators operate, and the challenges they face in respect of a fractured era defined by geopolitical frictions, threatened pandemics. Those who think that the COVID pandemic is behind us, this is just the tip of the iceberg. There is a lot more to come, and I hope I'm mistaken about this, but the world is yet to see that. Threatened pandemics, trade wars, looming economic crises, tensions between proponents of nationalism and supporters of internationalism, decline in tolerance, increased polarization between the East and the West, the North and the South, reduced common vision as to the importance of the rule of law and peacekeeping, erosion of the appreciation of the importance of coexistence, rapid depletion of natural resources, unsustainability markers, armed conflicts, and more. Throwing all the above into the mix, the contemporary responsible arbitrator is constantly subject to stress testing and is facing constant challenges that I list below, though I profess that the list is much longer. 1. The so-called golden age of arbitration is currently weathering a storm of scrutiny, forcing the community to confront existential questions regarding legitimacy, and I will come to legitimacy later, functionality, efficiency, and the ethical architecture of the international arbitration system, not only in ISDS, but also in high-stakes commercial arbitration. 2. Arbitration and arbitrators are criticized for determinations resulting from a fragmented system not of their creation. 3. Arbitrators continue to experience due process paranoia, but at a heightened and new level given the specificities of the fractured era that I will address shortly. 4. Issues of multi-hatting, disclosures, conflicts have been more dominant, more complicated, and more demanding, and they strike the core of the trust and confidence in the system. 5. Arbitrators are increasingly dealing with colossal claims and mega disputes, which complexity and ramifications have sometimes morphed into what we call a hecatonchires, which are the fierce and violent 50-headed and 100-handed creatures of the second order in Greek mythology. Claims that were not foreseen, nor did the procedural architecture of arbitration, no matter how the designers of the system thought that it would come to pass. 6. Arbitrators are also dealing with novel creations and uncharted sector-specific technical disputes and new generation instruments in fields like fintech, renewables, smart giga projects and cities, mining of rare earth elements, cryptocurrency, blockchain technology, cyber dealings, AI-related issues, ESG, to name a few. This is all in addition to the complications created by colliding and convoluted sanctions regimes, ramifications of armed conflicts, trade tariffs, resource nationalism, and competing overriding mandatory norms, public policy considerations of domestic, regional, and international nature. The above is not an attempt to defend arbitrators or invite sympathy towards those service providers operating in an ad hoc landscape without the support of permanent judicial structures like judges and courts. It is just an important attempt to shed light on the realities of arbitrating today beyond traditional misperceptions of glamour and pride. Now let me turn to my second part, which is the legal fracture, and that is the fractured landscape arbitrators and arbitrations are taking place in. Now at the outset, the word fracture has a specific connotation for the whole theme of this lecture. Apart from its linguistic meaning, to break or to shatter, derived from its Latin origins, I am more interested in its geological connotation. That is, a fracture occurring at a specific point, whether in time or space, of high stress, a material weakness or an existing flaw where the stress exceeds the material's strength. A fracture in that sense can be a tectonic uplift causing tensile stress. That said, the fracture we are witnessing today is a function of an intense interaction between the forces of globalization, localization, and regionalization. The world is becoming more and more divided, yet more and more connected, with events and actions taking place in distant territories, but affecting our localities and lives no matter where we are. We are indeed living in a world that is defined by the list that I mentioned earlier, including geopolitical frictions, trade wars, economic crisis, and reduced common vision to the rule of law. All this has contributed to developing a fracture, a break resulting from times and areas of high stress and systemic weaknesses in global governance. Across the geopolitical, economic, social, and legal ecosystems. And this is directly and creepingly finding ways to manifest in the world of dispute resolution and the global landscape at large. Now, moving from the macro level overview to a more micro level analysis, if we zoom in on the existing legal fracture, a fragmentation is immediately visible. The fragmentation encompasses the proliferation of specialized and often conflicting legal regimes, the erosion of multilateral consensus, and the retreat from universal legal principles and traditional value system norms in favor of a more national, bilateral, regional, or even unilateral approaches. This phenomena is visible across several interconnected dimensions. Normative fragmentation, where we have conflicting and competing legal standards and obligations. Institutional fragmentation, competing regimes, systems, institutions, and fora. Interpretive fragmentation, relating to divergent jurisprudence and inconsistent outcomes in decisions. Geopolitical fragmentation, involving rise in nationalism and weaponizing law and regulation at national and regional levels, leading to polarized and divergent approaches to certain issues having profound legal implications. Now, in respect of institutional and normative fragmentation, I would like to draw attention to the ILC, the International Law Commission's report on fragmentation of international law, difficulties arising from diversification and expansion of international law. Now, that report acknowledged the reality and inevitability of fragmentation within the international legal system over the past few decades. The rationale for that fragmentation has been coined as the emergence of new and specialized self-contained systems and regimes and geographically and functionally limited treaty systems that seek to respond to new technical and functional requirements, though this has created problems of coherence at the international level. Now, this fragmentation has over time created a fracture powered by a process of rapid technical specialization, diversification, and polarization at the national, regional, and international levels, and has given rise to a splitting up of law and institutions in highly specialized boxes that claim relative autonomy from each other and from general law. The increasing fragmentation and the present fracture were products of an uncoordinated growth of specialized legal regimes and systems, which is a paradox of globalization. The ILC report and certain scholars presented a realistic, pragmatic perspective by stating that it is a normalizing fragmentation, arguing that while it is politically inevitable, it remains legally manageable through techniques of interpretation. An emphasis, in fact exclusive emphasis, was given to the importance of the 1969 Vienna Convention on the Law of Treaties, the VCLT, as a unifying framework aimed at resolving conflicts and clash of norms in different fora and at different levels. Now, from my own perspective, this may be helpful in part in respect of interpretive fragmentation when it comes to decision making, but it is inadequate in respect of institutional, normative, and geopolitical fragmentation, and the resulting systemic fracture arising therefrom. In practical terms, the VCLT could not help much with treaty withdrawal, non-compliance, forum shopping, forum paralysis like the WTO appellate body crisis since 2019, or even divergent national and regional approaches to sanctions and the creation of parallel fora to hear and decide disputes, or even the power diffusion beyond Western powers, which is leading to diminishing consensus over rules that have long been established as a common understanding of the legal order. If we are to unpack all this in the context of international arbitration, it is clear that effectively the existing fragmentation and fracture presents jurisdictional challenges, applicable norms challenges, decision-making challenges, and enforcement challenges. Obviously, arbitrators have to directly deal with the first three sets of challenges, and indirectly with the fourth, that is the enforcement challenges, which national courts normally deal with directly. In respect of institutional fragmentation, the existence of a multitude of fora, whether permanent or ad hoc, to resolve cross-border disputes has caused the development of parallel tracks of jurisprudence, interpretive methods, and institutional cultures. And international arbitration was not immune or shielded from all that. And it did spawn its own third culture, methods, procedural frameworks, and approaches to decision-making powers, which in turn contributed to the ensuing fracture. Many would argue that such a fragmented universe involving a constellation of separate systems and institutions that apply a multitude of now colliding norms is chaotic. It does not inspire much confidence in the whole system and its constituent elements, and undermines the very existence of predictability, certainty, and consistency. However, predictability, certainty, and consistency lie not in the rigidity or the blind adherence to precedents or jurisprudence constant as it develops. This is because change is inevitable and the development of our legal universe is unavoidable. Since we are in London, I have to recall the wise words of Lord Denning in Packer versus Packer, when he eloquently said, "If we never do anything which has not been done before, we shall never get anywhere. The law will still stand still whilst the rest of the world goes on, and that will be bad for both the law and the world." Thus, the key issue for predictability, certainty, and consistency is the reasoned engagement with previous decisions and explaining why they are to be followed or departed from. This is what inspires confidence and enables the development of law. In Confucian philosophy, superiority is attained through harmony, not uniformity. And harmony can exist within fragmented and fractured systems insofar as conflicts, tensions, and clashes are managed peacefully under an overarching respect to the rule of law and within an ecosystem that is founded on cooperation, collaboration, and mutual respect to a set of supreme value system norms. While I would not go as far as Ronald Dawkins, who forcefully reminds us in his book, Taking Rights Seriously, of the crucial fact that jurisprudential issues are at their core issues of moral principles, not of legal fact or strategy, it is worth recalling that the suggestions, solutions, and even the way of framing issues that are proposed by studies in comparative law contain both authoritative elements and rational elements. These are the positive law in force in different countries and the interpretation by local judges and the reasons behind those authoritative legal decisions. The solutions drawn from comparative law have and can have some influence insofar as a basic principle of justice demands that similar cases be treated alike and different cases treated differently. Noting that the judgment about similarity and differences naturally requires the use of homogeneous categories. Now, having addressed the existing fracture and the normative, institutional, interpretive, and geopolitical fragmentation, I turn to the realms and how they interact with international arbitration. The word realm, meaning a kingdom, a field, or a domain, in Latin regnum, has in its origin effectively in the combination of two words, regalis, royal, and regimen, which is the government. To better understand the implications of the existing fracture on international arbitration and arbitrators, it is important to look at the competing realms from the perspective of normative and institutional fragmentation, and then address how this matters for international arbitration as an institution and a system that sits at the crossroads and an intersection of these orbiting realms of international, regional, and domestic laws. Now, the contemporary legal landscape is no longer a collection of isolated Westphalian silos, but rather a labyrinthine architecture of competing and interacting jurisdictions. It is a stratified ecosystem where domestic, regional, and international legal orders engage in a complex, often porous, and I will come to the reference to porous, choreography of normative exchange. This interaction is rarely a seamless integration. It involves a dynamic tension with high and low frictions, a tectonic grinding between state sovereignty and nationalism on one hand, and the irresistible forces of globalization and harmonization and internationalism on the other hand. At the foundational level lies domestic law, and it's not one size fits all. States have different laws even at the domestic level, but that is the bedrock of a sovereign state. Then hovering above is the international legal order, with international law as its scepter of justice. Wedged precariously between both are regional systems of law. They are supranational in nature, but confined to certain territories or regions that transcend the geographical boundaries of individual states. Now, this ecosystem encompassing those realms of the domestic, the regional, and the international reflect legal pluralism, but that involves interaction, competition, and cross-fertilization. Each of those realms has its own guardians, normatively and institutionally. That includes legislative bodies and national courts at the domestic level, regional institutions and courts for regional laws, and the international institutions like the UN and international courts for international law like the ICJ or ICLOS, for example. Now, those guardians do not operate in a vacuum, and they deploy and indeed employ various tools to defend their realms under the overarching rule of law as a universal tenet that is sometimes very visibly respected and in other times invisible and transgressed, especially when fragmentation spins out of order and the legal fracture widens. Among the tools that are deployed to defend domestic and regional realms are mandatory laws, public policy considerations, supreme national and regional interests, of which sanctions and counter-sanctions are a manifestation. In respect of the international realm, primacy of international obligations through treaties or jus cogens is among the powerful tools deployed to attempt to bring order to chaos, to bring wisdom to this scene of fragmentation. Nevertheless, the power play and institutional dynamics among the guardians of the realms are in a constant state of flux, and a harmonious equilibrium is not always found. And the disequilibrium that sometimes reigns is a function of the statics and dynamics of the international legal order and the unity and division among Leviathan state actors. As if competition, tension, and sometimes collision between those orbiting realms are not enough, another layer of complexity lies in what I call intra-realm dynamics, which refers to a state of fragmentation and discord within a given realm. Take the international law realm, for example, the interface between public and private international law manifested a division that has caused friction not only in academia, but in the application of legal principles by international tribunals and courts. Because public international law primarily looks at rights and obligations of states as the supreme players within the global community of states. And private international law, which serves as a bridge between domestic and international law, is concerned with the relations involving foreign elements and the ensuing rights and obligations in a transnational context, even when individuals and corporations are interacting with states. Though I must say that both public and private international laws interact harmoniously and cross-fertilize in many instances, even if proponents and guardians of those intradynamic realms are too proud to sometimes acknowledge. Now, on this topic, I would highly recommend to you reading Professor Campbell McLachlan's Hague Academy General Course, which was published in 2025 on the interface between public and private international law. It is volume 446 of the collected courses of the Hague Academy. It is because of this multi-layered cross-realm and intra-realm dynamics within the existing legal fracture that everyone is in search for a balance to be struck between state policies, public interest, and pluralism on one hand, and international trade, commerce, private interests, and party autonomy on the other hand. Noting that fragmentation and fracture present risks and challenges when these realms collide and occasionally attempt to cannibalize one another at times of crises and global unrest. But ultimately, the relationship between these realms should not, and indeed cannot, be one of constant tension, friction, and collision. We all tend to forget, undermine, and downplay the porous nature of these realms and the cross-fertilization that have ensued over long decades. The principles of pacta sunt servanda, good faith, res judicata, estoppel, which is venire contra factum proprium, equity, exceptional circumstances, abuse of right, unjust enrichment, proportionality, reasonableness, legitimate expectations, and even due process are all leading examples of international law principles that have originated in domestic law, but were subsequently adopted and morphed into general principles of international law with different dimensions and applications. Their migration is grounded in comparative legal analysis and is well documented in various ICJ and PCIJ judgments, arbitral awards, and doctrinal commentaries. The legitimacy and universality of those principles in international law depend on their demonstrative recognition across diverse legal systems. Article 38(1)(c) of the Statute of the International Court of Justice, known to all of us, recognize general principles of civilized nations, even though the word civilized connotes a colonized sort of philosophy. As a primary source of international law, these general principles are typically distilled from a comparative analysis of domestic legal systems and are adopted into international law when they are found to be accepted or common to a wide range of national jurisdictions. The process ensures that international law is grounded in the shared legal experience of states and reflects principles that have proven their value and legitimacy in domestic context and over extended periods of time. But also there is cross-fertilization and a degree of fluidity between the domestic, the regional, and international regimes, such that the integration of the regional and international law regimes into national legal systems, like the domestication of regional and international law, leads to influencing domestic law from both a hierarchical and heterarchical perspectives. By way of illustration, think of the first principles of supremacy and subsidiarity of EU law within the EU legal system, and how this originally demarcated the boundaries and defined the interaction between domestic law at the level of EU member states and EU law at a more regional level. Similarly, interactions between international law and regional legal systems, such as the European Union law, the Mercosur, the ASEAN, NAFTA, resulted in some recurring challenges which international adjudication and international arbitration had to deal with. And methodologies have been developed to address those challenges and resolve tensions in search for more coherence and more legitimacy and functionality of the international legal order and its constituent realms. At this level, international courts and arbitral tribunals have resorted to a range of methodologies to resolve conflicts between the international, the regional, and the domestic realms and norms, including, to name a few, characterization, compartmentalization, interpretation, combined and distributive application of legal norms, hierarchical and heterarchical perspectives in case of irreconcilable normative clashes. The solutions have not always been perfect and have not been accepted by many, but these are the tools that the present state of play offer. So where is international arbitration from all this fragmentation and realms collision in a truly fractured legal landscape, characterized by crises, armed conflicts, resurgence of economic nationalism, unilateral and multilateral mandatory sanction regimes, heightened national security policies, and adherence to domestic and regional legal supremacy, all presenting significant and serious challenges to arbitrators as ad hoc decision makers, who do not render justice in the name of a certain state, do not have a lex fori, do not function like national courts, and do not even have diplomatic immunities or protections. International arbitration stands at the intersection of all those realms and has made profound contribution to the advancement of the international, the regional, and even domestic laws. Through landmark awards, doctrinal innovation, procedural adaptation, arbitral tribunals have clarified legal standards, harmonized overlapping regimes, and developed methodologies for resolving normative conflicts. However, as new challenges emerge and emotions run high, international arbitration became a victim of its own success, and the whole system became the focus of the world and forced to be judged and subjected to scrutiny. Do not be mistaken, this is not an attempt to defend international arbitration as a distinct institutional realm, or an attempt to be complacent about it. It is simply an attempt to reread the global landscape, unveil the conditions under which arbitrators, as decision makers, operate, and an invitation to revisit some of our thinking, views, and perceptions. To set the stage, and before I move to my final part on system recalibration, I present you with 8 observations that I think are quite relevant to the role of international arbitration at this era and at this age of legal fracture. First, it cannot be disputed that the tremendous efforts that have gone into the development of international arbitration resulted in the creation of a globally available means of resolving international disputes. It remains important and necessary, and still is the successful mode for resolving cross-border and transnational disputes. Globalization and intensified cross-border dealings have brought about a fundamental change to certain aspects of public and private international law. From a public international law perspective, sovereign powers, and more broadly sovereignty, has undergone a degree of change by the state's own will to accommodate the new paradigm where states bind themselves by their own undertakings to arbitrate and to respect awards and enforce them. And they can also agree to the application of non-national norms in disputes with private entities when that is acceptable to the state. From a private international law perspective, party autonomy became a reigning master. It has morphed into a titan. And this has led to a rise of arbitration as a dominant form of dispute settlement for commercial disputes. Now, the success of international arbitration was not inevitable. It required common vision, diplomacy, and a shared commitment to the rule of law that transcended armed conflict, ideological divisions, and movements towards nationalism and alienation. Second, arbitration and realms of legal norms are not comparable equivalents or counterparts. In other words, arbitration is not competing with those realms. Arbitration is a process, a procedural framework that involves the application of these multifaceted legal norms. This is important because expressions of disenchantment or discontent with arbitration do not necessarily relate to the process itself, unless we're talking about time and costs, challenges, but they relate to the decision makers involved and their substantive determinations, case outcomes, especially in an age of what I call Geiger claims, multi-billion, tens of billions, and hundreds of billions cases. Third, from a philosophical standpoint, fragmentation and fracture challenges the exclusivity of a traditional Kelsenian hierarchy of norms approach and raises fundamental questions about the future of legal pluralism. The collision of regimes cannot be resolved by traditional conflict rules or hierarchy of norms. Instead, we need a new understanding of the relationship between the competing realms and legal orders, one that integrates a hierarchical coordination approach. Fourth, Jan Paulsen has eloquently said that arbitration is not the rejection of law. It depends on the law, but claims a special place. It is an application for advanced membership, not apostasy. And that is true. And I say that because there's been an ongoing debate in the past days about arbitrators not applying the law, and that doesn't matter because it's not a ground for setting aside. But I agree that ultimately arbitrators are bound by the law, and they should do even more effort to respect it, even if an appeal is not there. So arbitration distances itself from arbitrariness. Hence the use that I made throughout this lecture, a responsible arbitrator. Arbitration distances itself from arbitrariness and associates itself with the rule of law. The late Emmanuel Gaillard advocated for international arbitration as not merely a dispute resolution mechanism, but a legal order unto itself. And we're all familiar with his approach and his book about the legal philosophy, or the aspect philosophique de l'arbitrage, and effectively how French courts has carried that legacy forward with the delocalization thesis. And some courts have bought into that, and others have not. But others have reasonably disagreed. Lord Mance, for example, who articulately stated in his 2015 30th Freshfields lecture, said, arbitration already faces problems in maintaining coherence in its own jurisprudence and confidence in its efficacy and appropriateness as a dispute resolution mechanism. He goes on to say, I suggest that these could be exacerbated if either arbitration or courts dealing with arbitration issues seek to declare unilateral independence. Now, beyond the academic and the practical and the judicial division over that, one common denominator arises between everyone and all the competing views. That is, international arbitration remains indispensable and is the most prominent dispute resolution process, though reforms are required for successful sustainability. Fifth, Professor Campbell McLachlan is right to say that much of the best thinking about law has indeed been produced in times of crisis. This is very relevant to our age of legal fracture and to the development of international arbitration. Arthur Goodhart, in his essays in Jurisprudence and the Common Law, cites examples of Bacon, Hobbes, and Bentham, each of whom lived at times of crisis. And he states that it is in times when the supremacy of the law is insecure and its various principles and doctrines are being questioned that we find legal philosophy of major importance. Arthur Goodhart drew an analogy between dispute resolvers, jurists, and warriors, suggesting effectively that they flourish in times of conflict. So meaningful reforms to international arbitration system are not obstructed by fragmentation and fracture. In fact, they are most needed at this time. 6, it is hard to think of a good reason to question legitimacy of international arbitration. And I know that this is a topic that people feel strongly about. Even at this age of legal fracture, simply because the two most successful conventions of our modern times, the New York Convention, which has 172 state parties, and the ICSID Convention in the ISDS realm, has 158 contracting states, both comprise the vast majority of states in every continent and representing every legal system and form of political organization, with even divided ideologies. This is a level of adherence that dwarfs any international instrument in the legal field by a very significant margin. There is really nothing comparable to these two conventions. And if we add a soft law instrument like the Model Law on International Commercial Arbitration, the trio eclipse any debate over legitimacy as reflective of the lawfulness and acceptability of international arbitration. Now, that said, we can certainly speak of functionality, operability, challenges, and even flaws of international arbitration, but not legitimacy. 7th, international arbitration has everything to do with the decision makers, the arbitrators. The investment, the trust, and the confidence in the arbitration system is tested through arbitrators and arbitral institutions. And this age of legal fracture presents a multitude of risks to arbitrators and arbitral institutions that makes it all the more challenging, but also interesting. In terms of arbitrators' powers, which people dare not speak about in this age of legal fracture, one of the underrated documents and unsung heroes in international law is the International Law Association report on inherent and implied powers of arbitral tribunals, which provide a comprehensive analysis of arbitral powers and group them into 3 categories: express, implied, and inherent powers. Noting that they are not unlimited powers, nor intended as a privilege. They are necessary powers to enable the arbitrators to undertake their duties in accordance with the applicable norms and the parties' agreement. But the due process paranoia and the constraints that sometimes shackle tribunals operating in an age of legal fracture and fragmentation have sometimes limited the arbitrators' ability to avail themselves of certain of these powers as and when necessary. 8th, back to basics. And I think this was, at least when I was preparing for my lecture, the most enjoyable part, is looking at the past decisions. If you go back to basics, it cannot be denied at an international level that international arbitration predated international courts. And if you go even in ancient times, it actually predated any form of judicial authority. But beyond the Jay Treaty of 1794 and the creation of mixed commissions to resolve post-Revolutionary War disputes and the Alabama Claims Arbitration of 1872, which are at the core of the genesis of the modern system of international arbitration, the PCA was established in 1899, and the ICC, International Court of Arbitration, was established in 1923 to administer international commercial and business disputes under the auspices of the International Chamber of Commerce, founded in 1919. However, the first permanent international court was the Permanent Court of International Justice at the international level. And that was established in 1920 by the League of Nations. And it operated between 1922 and 1946, and it dealt with about 29 contentious state-to-state cases and delivered about 27 advisory opinions. until it handed over and passed the baton to the ICJ, the International Court of Justice under the United Nations in 1946. Now, at the time, many principles set forth by the PCIJ and the ICJ derived their legitimacy, gravitas, and certainty from international arbitration. I have 5 examples to share with you. Time may not permit me to go through all of them, but I will share a few. In the very famous Chorzów factory case of 1927, now that is often cited left, right, front and center when it comes to full reparation of harm. Everyone knows that. That case, before the PCIJ, referenced arbitral tribunals in 2 ways. Now, the court was faced with a dispute regarding some claims arising and have been brought before the German-Polish Mixed Arbitral Tribunal. And Poland and Germany took different views. Poland argued that the compensation should only be paid once the German companies withdrew their claims before the arbitral tribunal, and Germany responded that Poland's obligation to pay damages under international law could not be delayed or blocked by proceedings before the Mixed Arbitral Tribunal. Now, the PCIJ ultimately agreed that the case before it was strictly an interstate dispute between Germany and Poland, not a claim on behalf of private companies. But secondly, arbitral jurisprudence was referenced by the court when it came to the approach and the assessment of damages. Now, I have the part, and I can read it, but I will move directly to say the following. As part of the court judgment, the court said that only the value of property, rights and interests which have been affected, and the owner of which is the person on whose behalf compensation is claimed, or the damage done to whom is to serve as a means of gauging the reparation claimed, must be taken into account. In referring to that principle, the court said that this is an accepted principle in the jurisprudence of arbitral tribunals. And now you see the circular references. Today, arbitral tribunals refer to the PCIJ judgment when the judgment referred to arbitral jurisprudence at the time. Even so, in the judgment, when you read it, the court went on to say, this is a principle which seems to be established by international practice, and in particular by decisions of arbitral tribunals. Now, other examples, like the PCIJ case of the Société Commerciale de Belgique in 1938, involving a dispute between Belgium and Greece, the PCIJ effectively referred to the arbitral award of 1936 and upheld it as being definite and obligatory and will not be looked at on the merit. ICJ judgments have also referenced arbitral awards, and they were not sporadic references. Even in a 2002 dispute between Cameroon and Nigeria, the ICJ relied in part on arbitral awards to explain the relevance of state activities to territorial sovereignty. Now, when we come to sovereignty, it is a creature of international law, public international law. So you're referring to arbitral awards in that, and they refer to the Run of Kutch arbitration case and the Beagle Channel arbitration case to consider whether certain governmental activities is evidence of territorial ownership. Even at the Nottebohm case, the dissenting opinion of Judge Reed referenced arbitral awards, looking at double nationality and how arbitral bodies had to choose between 2 competing nationalities of an individual and determine which is most connected to which state. Even recently in the ICJ Nicaragua versus Colombia case, 2023, and in respect of the question of the delimitation of the continental shelf between Nicaragua and Colombia, beyond the 200 nautical miles from the Nicaraguan coast, the court expressly referenced the Bay of Bengal arbitral award in its reasoning. Now, these are just few examples. However, in fairness, I have to say, international arbitral awards also refer to ICJ and PCIJ judgments, and scholarly commentaries recognize that these references are commonplace in ISDS proceedings. Now, that said, some writers have even went as far as characterizing arbitrators as lawmakers. For example, Dr. Dolores Bentolela defended a PhD in the in the Graduate Institute of Geneva and published a book under the title Arbitrators as Lawmakers. Now, the argument made by the author that arbitrators in international commercial and investment disputes create core principles of law through consistent arbitral decision-making, taking the form of jurisprudence constante in certain cases, and principles, especially if aligned with the content of applicable norms and international law. Now, anyway, whether we think of international arbitration as a law-aligning, law-abiding, or law-making process, it is certain that its principles transcend geography and culture, though it has been shaped by both. Now, in light of these comments, I move to my concluding remarks about system recalibration. And recalibration, to me, originating as well from the Latin word calibratus, describes the process of adjusting, remeasuring, or adapting to change the way we do things effectively. Now, as stated above, yes, we are in an age of fracture. Yes, the whole world order and its subsystems are under stress, and the realms of domestic, regional, and international law, as well as in international arbitration, are no exception. Yes, the functionality and operability of international arbitration as a system is questioned, rightly so, but legitimacy still remains intact. So let us not mistake scrutiny for condemnation or reform for collapse. Marcus Aurelius, in ancient times, effectively observed that everything we hear is an opinion, not a fact. Everything we see is a perspective, not the truth. This ancient Stoic wisdom reminds us that the fracture we perceive, the crises we lament, and the challenges we confront are themselves interpretations and perspectives shaped by events of our era. So to recalibrate systems, we need to revisit our perceptions and reflect on the genesis and the evolutionary path of these systems. Although the fracture is real and the fragmentation is inherent, these could be signs of maturity, success, and sophistication, rather than failure and disintegration. A mature and sophisticated system, as international arbitration, has significantly contributed to the development of the rule of law and norm generation, invites intense examination precisely because it matters. The criticisms levied against it is paradoxically the most resounding testament to its significance. The global public engagement in vigorous debate over investment arbitration and dispute resolution, with the spillover effect on high-stakes commercial arbitration involving state and state entities, affirm through their very contestation that the indispensable role this system plays in the architecture of global governance and conflicts management. Justice Louis Brandeis, in his dissent in Olmsted versus the United States in 1928, once reminded us that the greatest dangers, and by the way, that dissent, if you look at it, it's almost one paragraph. So it's not about 100 pages dissent. Reminded us that the greatest dangers to liberty lurk in insidious encroachment by men of zeal. These are his words, I'm more gender neutral, well-meaning but without understanding. So it is perfectly sensible to accept that without criticism, laws, processes, and institutions cannot evolve. But without challenge, systems cannot strengthen and develop. Without criticism, but criticism and challenges must be premised on tangible evidence and facts, not idiosyncratic misperceptions, at least to ensure that reforms are moving in the right direction and are well justified. In an age of legal fracture and while undertaking their missions, arbitrators, responsible arbitrators, stand as impartial and independent guardians, not of a specific exclusive realm, and certainly not of personal interests, one would hope, but of the rule of law and as custodians of a sacred trust bestowed upon them by parties who seek not only justice, but closure by fair-minded, reasonable people who have competence and expertise, who are expected to wield their responsible powers to arrive at the most sensible and correct outcome in the circumstances, through meticulous and careful reasoning that is firmly grounded in the facts and the law and the arguments put forward by the parties. I say that because in instances, arbitrators and awards are attacked that they have not observed the law. But dare we not look at the submissions by counsel to look at what counsel has been pleading and what the authorities on record are? Now, one might say we should not be bound by that, but that takes you to the realm of Jura Novit Curia, an arbiter. And when you go into that realm, people say, oh no, you should not go there because arbitrators cannot surprise the parties in that sense and for many other reasons. So amidst this overview of the situation that we see, a degree of sensibility and common sense need to be found. The system we have inherited is the magnificent product of centuries of human aspiration towards a world governed by law rather than by force. From the pious fund of the Californias, which is the first PCA case in 1902, to the sophisticated investment and commercial arbitration framework of today, each generation has contributed its stone to this cathedral of justice. International arbitration has been instrumental in providing peaceful alternatives to force in the resolution of international disputes, developing substantive legal principles across multiple domains of international law, establishing procedural frameworks for fair and impartial adjudication, creating enforcement mechanisms for international obligations, promoting legal certainty in cross-border transactions and relations, democratizing access to international justice, and building an institutional infrastructure for peaceful settlement of disputes. The system's success is witnessed by many and evidenced by its ability and agility to continuously evolve to address contemporary challenges while preserving the core value system norms that holds any fragmented architecture together. Now, I've mentioned value system norms many times. Now, these value system norms are the foundational moral, cultural, political, and social principles that guide behavior and shape what a community, an institution, and a legal order considers legitimate, desirable, or worth protecting. They constitute the deepest layer of normative structure, shaping the priorities, the assumptions, the understanding, and the underlying effect and aims of other norms. They actually inform public policy considerations, and they are subject to the principles of relativity and actuality in the sense that they change over time. Value norms infuse legal orders with legitimacy, coherence, and stability. They enable the resolution of norm conflicts, guide discretionary decision-making, and ensure that the system evolves responsibly in response to domestic, regional, and international changes. In international law and arbitration, where authority is often decentralized, value norms serve as the invisible framework safeguarding trust, predictability, and fairness. This is fully aligned with Rawls' veil of ignorance and theory of justice. So, between exaggerating voices for and against international arbitration lies a path for moderating and reforming its flaws, in hope that the concerns over its functionality, operability, methods, and outcomes will be addressed. The trajectory we must chart is one of measured reflection and rigorous informed critique that does not exaggerate the perils we're facing, but moderate responses with wisdom and proportion, and dissipate despair that does not serve any constructive purpose. To characterize every challenge as existential, or every critique as catastrophic, is to succumb to a miasma of despair that paralyzes rather than propels. The fractures we witness, whether normative, institutional, interpretive, or geopolitical, are not irreversible. They are natural tensions within a global system that has grown in complexity, reach, magnitude, and significance. This calls for system disintegration or wholesale substitution is not productive. It heeds no verdicts. They can all best serve as guiding markers along the discourse towards self-reform, catalyzed rectification, and meaningful regulation. Yes, we can have parallel options, such as international commercial courts, and I will come to that shortly. And that is healthy. In fact, I see it as very healthy, because it will push arbitration out of its comfort zone and incentivize the community to return to the hallmarks of success of international arbitration and remedy its flaws. But parallel options coexist. They do not necessarily cause the demise of each other. In African philosophy of Ubuntu, which means I am because we all are, we find a profound truth applicable to our field. That is, collaboration, as simple as it may sound, is the art of thinking together without needing to think alike. We do not need to be the same. We do not need to look the same. We do not need to speak the same language or share identical perspectives to appreciate that we face common challenges. A shared vision of a greater realm, one that is the sum of all sub-realms that interact and may well collide, will enable us to emerge with less friction, fewer scars, better reconciliation, and more collaboration in finding solutions to common problems. The idea is not to collapse all the realms in favor of one unified realm. History tells us that this is impossible and is not sustainable. But what is necessary is to find harmony and coexistence between all interacting realms so that the overarching principles are respected and adhered to bring order to chaos while maintaining diversity and distinctiveness of each realm. Arbitrators are service providers and responsible practitioners and professionals. They should not treat international arbitration as a profit-generating business venture. We remain service providers of justice-related services, and we remain committed to a core set of normative values that define us and inform our work, values that fortify legitimacy, boost systemic trust and confidence in what we do and what we render. We are not the first generation to face crisis, although the complexity and the magnitude may be different. But every generation of cosmopolitan practitioners have confronted challenges that they thought was insurmountable at the time. Think about after First World War, Second World War, and after the Cold War even. Each generation had its tools and had to deal with the wisdom it possessed. Fragmentation properly understood is actually a sign of sophistication and specificity, and can be managed insofar as the larger universe of realms and ecosystems subscribes to a set of overarching norms that serve as guiding markers. In the age of legal fracture, amplified by the magnitude of novel challenges, we cannot afford to solve our problems with the same thinking, as Albert Einstein taught us. In fact, Jose Santayana, in his Life of Reason, has rightly said, those who cannot remember the past are condemned to repeat it. And I think humans excel in repeating their mistakes. Our responsibility is to contain the legal fracture, to improve our global system, not to abandon it, to reform, not to destroy it, to continue building, not to let it collapse. We all know that the rule of law presently has weathered storms before, but has emerged stronger. Peace is not granted, it is earned, and it must be built. International arbitration is one of the institutions that build peace. Imperfectly, yes, but genuinely, I hope. As Chief Justice Sundrash Menon eloquently articulated in a recent speech on the 5th of November at the inauguration of the Bahrain International Commercial Court, he said, "In a world as interconnected as ours, the law serves as a global currency of trust that keeps the wheels of commerce turning. It is a shared language through which nations, institutions, and businesses are able to transact across borders with confidence. The rule of law is not simply a domestic construct, but a universal bridge that sustains commerce and enables commercial parties to effectively work across communities, continents, and cultures. But for the law to perform these functions well," Menon says, "it needs a degree of coherence and consistency across borders, And that is the core purpose of thinking about this in terms of a transnational system of commercial justice. Now, the views expressed in this lecture are not intended to offer draconian verdicts, nor do I venture to own the truth at all. It is simply a call to recognize that the thread of commonalities uniting us has indeed spawned a third culture known to all realms and coexist with them in harmony. As Albert Camus said, you cannot create experience, you must undergo it. So too, we have no option but to face this legal fracture, this existing fragmentation, with courage, reason, and wisdom, and with the unshakable commitment to the rule of law that transcends fractures and fragmentations of our age. When recalibrating, I will leave you specifically with 3 comments. 1, recalibration demands a new intellectual posture that acknowledges fracture and accepts complexity without succumbing to paralysis. One that recognizes power dynamics, but strives for reasoned and principled engagement that is premised on adhering to the rule of law. Arbitration's enduring legitimacy and its proper functionality and operability depends on confronting these new legal and factual complexities, willingness to engage critically and constructively with its own flaws, and the readiness to shield arbitrators, responsible arbitrators, from frivolous attacks while maintaining avenues for genuine accountability. 2, draw wisdom and lessons from Jack Ridge's book, Building or Rebuilding a Civilization. That is a book that came out in 2024. And even though it addresses the rebuilding of a civilization, my thesis to you is that it works for civilizations, surely it can work for international arbitration. And it presents 5 core pillars: ethically anchored sustainability, no reconstruction and no calibration without moral purpose; institutional legitimacy, knowledge, adaptability over rigidity, in fact, Darwinism in system creation and development to ensure that they evolve and adapt; and community-centered action, collective public good and guided planning that rises above individual interest. I submit to you that all those 5 pillars can help charter a new path of excellence for international arbitration if taken seriously. Third, emerging or alternative structures like permanent courts, appellate mechanisms, and others need not be viewed as mortal enemies of international arbitration. Complementary components in a broader multi-door architecture of transnational justice, they should be. In our world, change is inevitable. It is a constant reality, an unexceptional norm. However, what always matters is the motivation and the underlying reason for such change, as this will inform the scope and direction and time. Permanent and ad hoc systems coexist. They are not mutually substitutive. Distinguished colleagues, the tide is high, the tempest is rough, but every step we take, every procedure we refine, every case we decide reasonably and fairly, every award we reason transparently and adequately, every reform we undertake in good faith, strange enough, being in London with English law, good faith reference, and based on informed data, brings us closer to a system that is not merely surviving a fracture, but recalibrating through it. Thank you so much for your attention and patience.
I'm Robertson, and it's going to be my pleasure to moderate the questions that I know that we are going to be getting from the audience here. Needless to say, Mohamed's presentation was thought-provoking. Couldn't be anything less than thought-provoking with Mohamed. And so, who has a question? Corinna, we have a microphone. It's coming here. Would you please, if you have a question, state your name and then your question.
Krina Baltag, Queen Mary University of London. Thank you very much, Professor Mohamed Abdel Wahab, as always inspiring. While you're mentioning the PCA cases and the ICJ cases referring to arbitration, I thought for a moment to Judge Lagrogan, the first president of the Iran-US Claims Tribunal, and the 2 arbitrations he chaired, the India-Pakistan 1969 and the TAB arbitration of Mount Sinai, Egypt-Israel in 1988. And both were very much, the outcome, positive outcome, was very much celebrated by the states at the time. And I was wondering if what is missing is actually for arbitration to be again celebrated by the states and not necessarily by the commercial users.
It is an excellent point and reference. I think at the genesis of it, everyone at a time wanted arbitration to be successful because that was the alternative to force, and that was the peacekeeping. Now, arbitration has spun off to become that very successful model that at some point felt that it cannot be contained. And when the big players have been sued, decisions have been rendered in billions, big question marks arise. And so the question became, these tribunals that I think about it like a puzzle. You build a puzzle and then you finish it in a way. So effectively they finish the work and then go. Who's accountable for what? And you're going to live with the decision as a state or a state entity or even as an investor or a business or corporate entity. You're going to live with that. The reality is the rules of the game have not changed. But the game has become very sophisticated, very celebrated, high stakes, not just high stakes, high stakes. And so the question is, should we reconsider the rules of the game again and now? And I think if you effectively engage in a system and structure it in a way and it functions, over time, effectively it outgrows the rules that have been put in place. And so certainly we need to reconsider the flaws of arbitration. For example, the first thing that we teach students in arbitration, I don't personally say that, but they tell you arbitration is cheap and fast. And it's not. When it was democratizing access to justice, today the costs are prohibitive. And they'll tell you third-party funding. And immediately when the idea of third-party funding came to light, it was sold as access to justice. And at the time I said, it is never about access to justice because they are corporate entities. They need to make money. So you have actually, along the way, because of the success, to some extent, forgot the purpose and goal of the whole process and system. And I think we need to go back to those basics. And if we go back to those basics, people will buy into the system. But now, at this time of fracture, where effectively force and wars are an option, the value of arbitration is diminishing. Because if you accept violence as an option, you will not accept arbitration as the alternative.
We have another question. How about over here on this side? And again, please give us your name.
Okay. Matt Malloy, London, Westminster Company of Arbitrators. Thank you very much for really insightful lecture, a real tour de force. If I understood you rightly, you mentioned consistency, and I'm not sure if you're advocating that consistency of arbitral decisions is necessarily a good thing. But you also talked about the fact that we're in an evolving and developing world, and thinking in the sort of realm of public international law and ISDS in particular. Do you think that consistency, by which I mean following past arbitration awards, is actually a good thing to deal with that evolving and changing world that we're in? Thank you.
Thank you so much. Well, briefly on this point, if you ask people about whether consistency is desirable, they will have divided views. The reason being, it depends. If they are winning on the basis of consistency, the answer is yes, you need to be consistent. And if the answer is no, then not. And this is, for example, a new function of AI. If you have AI, it's going to look at the past decisions and render a decision in accordance with precedents. Whereas if you want to have your luck with a human element to convince them otherwise. I think we have a problem because we tend to think of consistency as a uniform outcome. And it's not. And that's why I mentioned in my lecture that consistency means that, one, you're not moving in an arbitrary manner. You're looking at the whole package, the past cases, and then consider whether your case is distinguished from those past cases or not. And if yes, reason why, and if not, reason why as well. And then move in that sense. This element of transparency in reasoning I think resolves the debate over consistency. What I think is the problem is that if you have people coming and they completely disregard any decision rendered and rule on the basis of their own idiosyncratic views. Now, that is not a good thing, nor is a proper thing to do. You need to consider the authorities and whether you agree or disagree and reason why. Now, if that happens, that gives you the degree of certainty and consistency. Consistency why? Not in the exact outcome, but consistency in the thought process and the reasoning with which you arrive to a certain outcome.
Thank you. Ooh, applause on that one. Lord Hacking, up here on the second row, please. And then I think we'll take the next question from our virtual audience.
I'm very flattered to be asked to put a question.
Could you hold up the microphone so they can hear you?
Can everybody hear me? I'm a retired international arbitrator and a long-time fellow of the Chartered Institute of Arbitrators. But I also have another activity, which is really a recalibration activity, because I have been involved in the House of Lords for a very long time, right back to 1979, in recalibrating our law. And very recently, we've had a new Arbitration Act. It's called the Arbitration Act of 1925, so it's right. Oh, sorry, 1925.
2025. Yes, add 100 there.
2025. And in that, we created something that has been practiced in the English court for years, and that's the right of parties to go for summary judgment or summary dismissal, which will cut out all of the proceedings in the arbitral forum and could have a very quick result. But the concern here is that there's no compulsion for an arbitral tribunal to acquiesce to that, and that it may be a calibration which has gone too far.
That is indeed. I mean, Your Lordship, thank you so much for your views on that. And I think everyone is now looking, well, the biggest concern now is time for everyone. But one of the things is time in terms of resolving disputes. And sometimes you may have claims that do not withstand scrutiny, and so you want them out of the way right away. But the reality is there are certain procedures, and due process paranoia plays a great deal in that effect. So yes, whether it has gone too far or not, it depends really. I can tell you based on my own experience from where I come, in our part of the world, our old laws on arbitration, and that's not just for Egypt, but across the MENA, did include a reference that arbitral proceedings will last for about 90 days. And at the time, it was thought, oh, these uncivilized societies, they would resolve disputes in, 90 days, not giving parties rights or not giving attention to the substance of the dispute. Now, full circle, today, expedited arbitration, fast-track arbitration, is not only the norm, and early determination, it is the fashion. Now, time will tell whether that would be a success story or yet another cog in the wheel that may lead effectively to nowhere.
I failed to say something, I think I speak on Professor Mohamed, that you gave a brilliant lecture. Yeah. Thank you so much.
So do we have any questions from our virtual audience? Let's hear one and see what's coming from afar.
We do. We have a question from Zafar Iqbal. What does guarding the realm practically require from international arbitration in this era of tension between global, regional, and national systems?
I will answer this in one word. Arbitrators need to take their work responsibly. Do not descend into the politics of things, because we have to decide on the basis of law. We cannot distance ourselves from the world we live in, but I think responsible decision-making and respect is the thing that provides more than the diplomatic immunities that are not present.
That was more than one word.
Yes, yes. I thought responsible was one.
Responsible is your
right.
word, yes. We have someone else that has a question here. Jonathan, here on the front row, if you could bring it around to Mr. Wood, please. Right here in the very front. I'm sorry, I didn't tell you where he was located. No. Here we go. Thank you.
Jonathan Wood. Thank you, Mohamed, my successor. Congratulations on a tour de force, as ever. The young, the youth, the up-and-comers are somewhat glamorized. You mentioned the word glamour. And I think they look at international arbitration with rose-colored spectacles. And yet you also mention the circumstances in which we all operate. And I don't think they realize how difficult it is in this day and age, because challenges are vicious. We talk about guerrilla tactics. Do you think we ought to be more frank with those who are hoping to follow in our footsteps and tell them what it's really like to be on the end of an injunction and contempt of court? It's not quite so glamorous as we thought it was when we were young.
You're absolutely right. And 2 years ago, whenever I get an application to join the firm as a junior, I sit them down, if they make it through the interview to come finally, and I tell them, why do you want to do arbitration? Events, travel, whatever. Now let me tell you the full story about it. You could be sued, you could be subject to injunctions, you sleep less, you're constantly under stress, you're pulled with gravitational pulls left, right, front and center, and you're expected to deliver justice and fairness. So when you explain this to them, of course, as bright, young souls full of hope and rosy, you can see that the smile is diminishing and the hope is, and despair manifests itself. But I think it is important that we tell them this, and they have to decide whether they want to live that experience or not.
How about here on the second row, on this side? And then we're going to go to our virtual audience again, because I think we have some more questions from them.
Wow. A lot of topics covered, Mohamed. My question is two-pronged. Number one, you mentioned uncharted territories. So AI, crypto, there's a lot of stuff happening over there. Are we really following the regime? And then the second thing is about the rule of law. Are we really now facing competition from the rise of commercial courts? And what is your view on it? Because you've mentioned it, change is inevitable, except in the vending machine. So we have to look at it from that perspective.
I generally think competition is always good. And I do that even in jurisdictions that, for example, prevent foreign lawyers from practicing on their own to protect lawyers in a jurisdiction. And for example, in Egypt, I tell people, even though you need to open with an Egyptian whatever, why not let international firms compete? Of course, then you have difficulty with retention on the financial, but competition is good because effectively it invites you to up your game. If you don't have competition, you do not have an incentive to be better. You do not have the candid view to reflect on your mistakes. And I think that's why competition is good. So think about it. Arbitration initially, what was there, it predated courts. When I was looking at the judgments, I mean specifically, the PCIJ citing tribunals to getting the gravitas and the benchmarking on a case, and today say, okay, arbitration is now shackled, constrained by its own problems. Let's have international commercial courts. That's good. Why not? It's a multi-door option that parties will have a lot on offer, and that competition will make everyone vigilant to do better. And I think that's fine.
Thank you. Let's go ahead. Do we have another one from the audience, the virtual audience?
Yes, we have a question from Funke Adikoya. To what extent has the system of sanctions contributed to the legal fracture of the realm of arbitration, and how can we recalibrate the system in a manner to guard the realm while also strengthening it so all parties have equal access?
So it's a very difficult question, but let me tell you this. Sanctions have existed for a long time. They are not new. The issue is the magnitude, the scope, and the proliferation of it. You now have sanctions, counter-sanctions, and you have people subjected to those sanctions beyond the disputing parties. And that is causing, effectively, an issue. And the only way, tribunals have to deal with it from a legal perspective, and we're all familiar with the issues legally you have to deal with it. But To what extent that is contributing? There is a contributing factor to the fracture, that is undoubted. Now, effectively, whether and to what extent you give weight to what and on what basis legally and factually is the question that tribunals are grappling with. But within that framework, I have to make one statement that I think we should collectively think about. Today, for example, if you have a sanctioned entity, certain nationalities cannot sit as arbitrators, certain institutions cannot take the case. Now, what does that tell us about the rule of law and access to justice? I would have thought, perhaps in a naive manner, that if it is a real dispute and it's all about the law, give the parties a chance and let them have their dispute considered. Now, that is completely different from sanctioning someone for terrorism or for illegal activities or whatever. But if there is a trial or a legal case, why is there a problem in having the case go forward? That is the natural forum. Because otherwise, you could effectively descend into the realm of denial of justice. How many cases today are commenced and then stopped because of sanctions? How many arbitrators, because of their nationality, cannot sit in certain cases? And I say that because perhaps others are benefiting. For example, I may hold a nationality that does not prevent me from sitting in cases. But I feel for colleagues who simply have another nationality, and because of that, they cannot effectively sit in cases. But of course, they have another benefit because they can travel to other countries without visas. I still have to apply for visas.
Do we have a question? Let's get one in the very back. Let's take the gentleman in the very back over there, please. And please tell us your name.
Well, my name is Mohamed Al-Habibi. I'm a judge at the Egyptian Economic Court, and I'm a scholar at SOAS University of London. Well, first of all, thank you for your speech, impressive one. And my question regarding the certainty. So the certainty in the context of the validity of the arbitration itself. So this certainty can be derived from the consent of the parties itself, or there should be a default rule in the domestic laws. Briefly, this is the question.
Thank you. So briefly, I would say arbitration is based on consent. Now, how we construe consent and its existence is a legal debate. But you require consent, and you normally would not go to arbitration without consent. Even at the level of ISDS, there are different forms of consent, but again, there is consent. It's a mechanism that requires users to buy into it. And the first users that bought into the system are the states, for valid reasons. That's why I say that element of states buying into the system, and the system cannot survive without the support, generally, of states, for the benefit of everyone, effectively. If you want to have investments and, let's say, bring in credible investors and businesses to the state, the first thing they will ask is that, do you have arbitration, and on what basis? They will not necessarily subscribe to national courts, not because of anything, but you don't want to play the game on the turf of the other party. So I think consent is key. The question is always debatable whether it exists or not, and if so, how.
Let's see, we have one in the back over here. This gentleman in the back, I'm sorry I'm pointing. Okay. Yeah, it's Doug. It's Mr. Jones. Go ahead.
Doug Jones. Mohamed, congratulations on the breadth of your lecture. But its breadth is something that I want to ask you about. State arbitration, arbitration between states, and investor-state arbitration is of a character both legally and politically completely different to commercial arbitration. And it's almost accidental that the commercial arbitration community has embraced, with enthusiasm in an adversarial way, ISDS, and to a certain extent can be accused of having to kill the goose that laid the golden egg by applying the adversarial techniques of commercial arbitration or commercial court proceedings in a way which the states no longer regard as acceptable. In your theses, you combine issues which relate to all of those three quite separate areas. My question is this: how do we succeed in separating the debates which arise under the phrase arbitration to deal effectively with what the Chartered Institute is really all about, which is commercial arbitration, and avoid feelings of guilt and worry which arise from those other two areas of so-called arbitration?
Thank you so much, Doug. You can see that the room is full of presidents and past presidents of the CIArb, and I'm just on my toes because each one of them is a towering figure. Let me say this: they are different. And Doug is absolutely right to say that accepting to play again with all three by the same rules was interesting. I think what we need to do is a thought process to look into that. One, is it best for everyone then to use the same rules and the same approaches, adversarial or not? And if not, what needs to be changed? So we need to identify the differences and the commonalities. But I have for example, certain states as well feel that in the ISDS realm, high-stakes commercial arbitrations involving state entities that affect public budgets, more or less, are not different from the ISDS. This is at least the view of some. And so to that extent, if you have a public law element and administrative law aspects to an arbitration, it imports to an extent elements of ISDS system. So this degree of fluidity has created the confusion to many. Now that is a bit different from the approach to how to prosecute those cases, because many instances as well, the firms that do commercial arbitration also do investment arbitration and state-to-state arbitrations. Now, they may be different practitioners or the same. And I'm not wedded to the idea that everyone should stick to one specific aspect. You need to know what rules govern what and how they apply. And I think that area is a little bit blurred, and I think it needs more work. And perhaps here, the Chartered Institute of Arbitrators, through thought leadership, through education and training, which is, I think, what the CIRB is about, can do a lot of work by creating an opportunity to bring together policyholders, state representatives, representatives from the business community, identify the issues that they have with the ISDS system now, and look at it, what needs to be changed. And perhaps if you jot this down in a paper and create a checklist, it might work. But I can tell you now that even representatives of states, if you take them into the room, they will speak of different problems. There is a common set of problems, and they will have different views about them, depending on the outcomes they've had in the cases. So that is also a very important factor. And that is something very interesting, because if we develop rules with the benefit of hindsight, we're going to change them with every outcome. And so the rules will no longer work because they will become outcome dependent. So it becomes a vicious circle.
I think we're going to make you the chair of that committee.
No, I don't want to be chairman.
Let's have one from the audience, the virtual audience. Do we have a question?
Yes, we have one from Judge Mohamed Al Nasser. In brief, what do you see as the greatest emerging threat to the coherence of the international legal order, and how can arbitration proactively mitigate that risk rather than merely adapting to it?
I think the greatest risk today is undermining the positive elements that arbitration has brought. Because today, everyone is talking about the flaws and the problems. And over time, you tend to forget the good things that have happened. And so when this happens psychologically, you're no longer open to accept the existence of the institution. And so that is the greatest threat, is that we need to look at the genesis of the system, follow its evolution, identify the pros and cons, and develop that objectively. But this element of disregarding everything and thinking negatively about it takes us nowhere. And I think that is the greatest threat.
And I would have to agree with you on that, especially in educating clients, because they're always afraid of arbitration, because the only thing that you see in the news is the bad news about arbitration.
100%. And I think here counsel owes clients a duty, and I know that in maybe the West and in the northern part is relevant, and they do it well, but in certain parts of the world, it is not uncommon that you get a client and they tell you, I'm going to win the case for you. And then the client has a very bad case and loses. And then guess what? They're probably not going to blame the lawyer. They will blame the arbitrators and arbitration. Right. And so I think counsel has an ethical duty and a professional duty to be candid with the party about the prospects of the case, about where they stand. And that will maintain a degree of predictability as to the system at large.
Do we have any other questions here? Oh, we have lots of questions here. Let's take the question here on the end, on the front, and then we'll take you next.
Hi, my name is Nader Khalil. I'm an attorney and a recent fellow of the Chartered Institute. Thank you for a very wide and insightful foray into the legal philosophy underpinning international arbitration. I think the core of your thesis, as I understood it, is a harmonious approach to managing tensions between these different realms rather than imposing the hierarchy of one over the other. But I did notice that you named your lecture recalibration rather than reconciliation or resolution, though earlier in the speech, and maybe to specify the question, you did refer to the earlier tensions between regional law and domestic law and refer to the resolution of those tensions. Now, arguably, the example of European Union law that you mentioned resolved those tensions precisely by imposing the supremacy of the regional law over the domestic law, at least since the 60s and 70s, setting aside domestic law where it wanted. And that sort of raises questions as to the suitability of this regional model for resolving those tensions. So my specific question to end this little monologue is to say, does the resolution or reconciliation of those tensions, is that a difficult or out of reach goal for us? And do we need to just manage those tensions? And if we do want to resolve them, what is the path in that direction?
Thank you so much, Nader. Let me say this. My structure was the following. Identify the conditions under which arbitrators are working. That was my first comment in the introduction. Then I moved to address the fracture in a descriptive analysis. Then addressing the realms and the problems that arise. And then recalibration, not just in terms of arbitration, but the legal system at large and the realms. And my take on this is the following, in answer to your question. Arbitrators will continue to deal with what they have, with what they can deal with, in accordance with the legal principles and the tools they have and the methodologies. You can't do anything beyond what is available to you. The call for the whole lecture for me was coordination. And this coordination needs to come from the major players, the states. And what my thesis, if you want this in a clear answer, is that the fragmented and fractured framework today serves the interests of no one. On the short term, you may think that I have, as a certain state or a player, dominance. But on the short term, the medium term and the longer term, it's going to be a lose-lose situation. Because effectively, the whole international system was founded on a common core of principles and norms that are based on cooperation and mutual respect. This is the whole system. If you take away the respect and the cooperation and you proceed unilaterally or bilaterally by building islands and alienation, what do you expect from a justice system operating in these conditions? That is the big question mark. Now, arbitrators and judges, look at ICJ judges having to deal with issues now that are colossal in nature, right? And if you get a state saying, oh, by the way, we do not care about the decision of the ICJ. Now, that previously was never vocalized or mentioned openly. You may have had states not complying, right? But to be vocal about it is a defiance to the rule of law. And that means that we have undermined the appreciation of the rule of law. And the way to deal with it is that the players need to buy into the system, not arbitration system, the rule of law system at its best and at its core, by accepting that the only way for us to move forward is together, hence the Ubuntu philosophy of Africa. Because if you move in one direction, with the cycle of civilization, there is always a rise and fall. And if you fall, it's going to be a problem.
The lady in pink has been very patient.
Yes.
I'm getting the signal. Sorry to jump in. This will be our last question, and then bear with me. I'm sorry to cut you off. I'm getting the signal from our events team that we're about to, we need to wind down the Q&A and transition to our presidential handover
well, thank
ceremony.
You very much
thank you so much.
And you get to be our last question, last but not least.
Thank you, and thank you, sir, for a thought-provoking
Please hold up your
Sorry,
microphone.
and thank you, sir, for a thought-provoking lecture. My name is Philippa Rowe. I'm a member of this institute and a reinsurance arbitrator. By definition, almost all reinsurance arbitrations are international. You devoted quite a lot of extensive time, I'm not complaining, to an analysis of the rather depressing shifting sands of international politics and diplomacy and legal bodies and institutional arbitration bodies and the effect they may or may not have on us in the future. And then right at the end in your peroration brought us firmly back down to ground by reminding us properly and firmly of our personal duties to act responsibly, ethically, professionally, correctly. Which of those two do you think will prevail?
I don't think those two are at odds with each other. I think the only protection for arbitrators and adjudicators and decision makers across all realms, if I'm to say, is to act responsibly and in accordance with the law and what they have. That, I think, is the guarantee to their protection. And I think that is the thing that invites respect. And let me tell you a clear example of that. In many instances, parties may lose a case, but they will respect the decision maker. Because they realize, even if I disagree with the decision, I know that the person, one, was not corrupt, two, did their best with what they have, even if their best is not good enough from my perspective. I think that issue of trust and confidence is the thing that kept any adjudicatory system alive and accepted. And as simple as this may sound, it is the only thing that helps arbitration or a court system, whatever, to survive. And so the only way is acting responsibly and with care. That, I think, is the recipe for success.
All right, since we have been told that you are the last question, please join me once again. And
Thank you for being patient. Thank you, Anne, and thank you, Mohamed. And if you'll indulge us at Ciarb, we are now moving to, as we mentioned, there's a lot of ex-presidents in the room. There are a lot, and we are now at a transition period in which we say goodbye, but not permanently, to Mohamed. And of course, we welcome in next, but I'm going to refer to a few statistics again. Over the last 11 months, and this is quite an astounding set of statistics, Mohamed has participated in over 100 events, of which encompasses 6 continents and 27 jurisdictions alone. And I can categorically confirm, and I believe you will also agree with me, that not a single speech was repeated through every single one of those. Astounding. The power of today's lecture, the power of the questions, and actually the knowledge base. Mohamed and I, on my 7th day, had lunch together not too long ago, and I'd noted that we only had presidents for a year, which I felt was astounding based on the knowledge, and I look at Jonathan in front of me and Nyla, that we lose as they depart. So officially, Mohamed and I have agreed to bring back what we call the President's Advisory Committee by reconstituting those individuals who've spent so much time and effort through their career at powering this profession, bringing you all back together on a more often to discuss where this profession goes. It is in transition, like many things within the rule of law currently, and it's important that the youth entering into this profession are engaged, and the knowledge of which sits in this room, and I include Doug in this. It's critical so that we continue to engage this. So before I say goodbye to Mohamed and welcome to Ciarb, we will keep you engaged, and we'll have more information on that. But we start with a lunch tomorrow as a round table. But I would like to very much thank you, Mohamed, for your time. And I would like a little gift. Now at this stage, I'd like to welcome up Ciarb as we transition.
Now, before I handle this, I have to introduce you. So let me say, I mean, this is a room full of presidents, and we have all of them here, and it's one of the things that I think is important, as Don has mentioned, and this was a thought that I had, is to have a presidential advisory board. And that's for the benefit of the institution. You can't have these towering figures, and many of whom are sitting today, just the institute not benefiting from their wisdom going forward. Naila, Jonathan, Anne, and by the way, it's an excellent president, but came at the COVID year, so we didn't benefit a lot. But again, an absolutely outstanding president. Doug, and many, many, many more coming as well. And Ciarb is the new coming, and we have Michael as well taking place and helm in 2027. So let me say this. As we look ahead in 2026, it is my pleasure to introduce Ciarb Pereira, the incoming president of the CIArb from Brazil. So I think he's the first Latin American president as well. So welcome. Ciarb is a chartered arbitrator and was the first chair of the CIArb Brazil branch. He is a partner with Justin Pereira and Oliveira and Talamini in Sao Paulo, and regularly sits as arbitrator and represents parties in international commercial arbitration in multiple jurisdictions. Ciarb on the board of directors of the Vismut East Foundation. He's a fellow of the University of Nottingham's Public Procurement Research Group, and in 2022 was appointed as the CISG Advisory Council by the CISG Advisory Council as rapporteur for its opinion on the application of the CISG to government contract. He is the author, editor, educator, and has been a visiting scholar at a number of universities, including Columbia, Nottingham, and George Washington universities. Ciarb is on stage. I have to say this. Now, my interaction with Ciarb goes well before this day. He's full of energy, enthusiasm. He brings in a fresh perspective. He brings Latin America to London. And I think it's going to be an outstanding presidency for Ciarb. I want to present you with the medal that I took from Jonathan, and now it's for you. I need you to wear it, perhaps. So I should give it to you now, and I'm sure you will hold it, not just as a medal, but with the integrity and the ethics that it comes with. Good luck.
Thank you, Mohamed, well, my dear friends and colleagues. It is really a pleasure and an honor to address you now very briefly. Don has already told you that the next stage is going to be the drink reception, and so this is going to be very brief. But as Mohamed mentioned, I think it's very significant that now we have the first African president of the Chartered Institute of Arbitrators handing over this very important medal to the first Latin American president of the Chartered Institute. I think this says a lot about how global we have become. And in 1 year, I will hand over this medal to Michael Tonkin, who's going to be the first non-lawyer president after 17 years. That also speaks volumes about our variety. And so this is indeed, in my opinion, a very important moment. Another thing that I think we should be very proud of in the Chartered Institute is our democratic system of election of presidents. The 44 branches vote. They choose someone to represent what they imagine for the Chartered Institute of Arbitrators. Only 6 years ago, I helped create the Brazil branch. And I see that election as branches willing to be represented by a vision that's not only mine, but a vision that's collective, a vision that is shared by everybody who was creating with me. Chair Cristina Mastrobono is here, Christine Santini is here, Fatima Bonassa is also here, many other Brazilian fellows of the Chartered Institute who believed that Latin America should have a branch, not only Mexico as part of the North America branch, but should have a branch of the Chartered Institute of Arbitrators after so much effort that had been done by professionals like Anne Ryan Robertson, who is my mentor and my example within the Chartered Institute, by Jeff Elkinson, who has been to every one of the accelerated route to fellowship programs that we have had in Brazil since 2013. Many of these people showed us in Brazil how the Chartered Institute could be important for Latin America. We believed in that, and we made that effort to bring it to Latin America. And I think that's the vision that branches chose when they honored me with this position, a vision of the unlimited potential of our decentralized organization that has almost 20,000 members, 44 branches all over the world, all able and eager to collaborate among themselves. A vision of global reach, a vision that we have space to grow in Latin America, in Africa, in the Indian subcontinent. So much that we can do. A vision of diversity, a vision of incorporating other languages into the Chartered Institute, Spanish, Arabic, Chinese. A vision of inclusion, a vision that CIArb branches in different places mean different things. A vision that non-central jurisdictions have fellows that are willing to have international visibility, international exposure, and we are the ideal platform to provide that. CIArb presidents, as you know, are asked to have a theme, and I, with the help of Kristen Bauer, brilliant Kristen Bauer, I have thought of my theme as being trust in a changing world. In trust in the meaning of a projection of ethics, trust in the meaning of dealing effectively and responsibly with the technological disruptions that we are living. But I like the idea of trust in a changing world, also for the hope, the optimism, in a way, that it projects. We are in a changing world, but we can trust that we will have the ability, we will have the capacity to adjust, to, to recalibrate, yeah, the ability to recalibrate in that context. And I don't think that CIArb can avoid its role as a thought leader, not only by words, but also by example. We have to do what we say. We have to show that we are that we mean what we say. We do have another thing that we must be very proud of, which is a very robust system of ethical enforcement. We don't know, many institutions have codes of conduct. We have a whole process to enforce our code of conduct. We have to be very proud of that. And that is the kind of trust that we need to project. We have to build, we have to preserve, we have to restore trust if needed, and as it may be needed. And so I'm very much looking forward to working together with Don, with Kristen, with everybody here at the central office in London. I'm very much looking forward to working with Ben in the whole Board of Trustees, with the new Presidential Advisory Council, which I think is a brilliant idea. Very especially, I'm very much looking forward to working with all of the branches. I'm kind of scared with the idea that Mohamed had to give 100 speeches, and so, well, I may have to repeat some because not everybody is as brilliant as Mohamed, but I'm very much looking forward to that. And so I receive this medal with a huge amount of humility and a great sense of responsibility to honor the great work of President Mohamed Abdel Wahab and all the preceding presidents that are here today and that are not here, until I can deliver the baton and the medal to Michael in a 1 year's time, who will then take us to even greater heights. Thank you very much for your attention.
Once again, thank you for everybody here and for everyone online. I appreciate your participation. We will be now quickly adjourning next door for some drinks. Once again, thank you for attending. I look forward to meeting all of you.